Welcome to Immigration Talk with Attorney Anish. Attorney Anish is an immigration lawyer who has been certified as a specialist in immigration and nationality law by the State Bar of California's Board of Legal Specialization.
Hello, you're listening to Immigration Talk with Attorney Anish. My name is Anish Vashista. I run an immigration law firm where we handle all types of U.S. immigration law cases. It is May 6th, 2019. It's a Monday, and it's been 1 week since President Trump issued a memorandum to the Department of Homeland Security providing for some changes to the asylum system. And today's topic is about asylum, both the existing law and what's being proposed by the new administration, and some other recent changes that have occurred. The crux of this discussion is that the law predominantly remains intact regarding asylum law here in the United States of America. Now, I want to just talk about briefly the changes that were announced last week, or should I say the proposed changes, because nothing has gone into effect. But essentially, President Trump ordered his new Secretary of Homeland Security to impose certain changes in the asylum system in an attempt to decrease what he views as frivolous claims. Now, some of these changes will affect everyone, and some of them will affect only a few people. But I want to talk about the changes that will affect everyone. What's being proposed is that there should be an application fee for asylum applications. There's a caveat that the fee should not be any higher than what the cost of adjudicating the asylum application is. As way of background, while the Immigration and Nationality Act, which is passed by Congress and signed into law by the President, does authorize an application fee for an asylum application, there currently is no a fee for an asylum application. So while there is the option to have one, the current regulations do not allow for it. Now, what President Trump is asking for is the proposal of new regulations that would amend that to reflect that there is now an application fee for the asylum application. Similarly, the other changes that President Trump is asking for have to go through the proposed regulatory process, which means that a draft of the rule has to be made. There has to be a notice and comment period, and then those comments have to be taken into account by the department before the final regulations can be made. The process is time consuming, and even though the president gave a 90-day deadline, that deadline, which starts from last Monday, April 26th, not April 26th, but last Monday, applies to when the proposed rules should be issued. So that was Monday, April 29th, when the president made that announcement. So within 90 days of that is when he wanted the proposed regulations to be issued, and then they can go through the notice and comment period before they can be made into final regulations. So that's important to take into account. So one is the application fee. Second is that there's also an application fee, not just for the asylum application, but for the initial employment authorization document. As many know, one can apply for an employment authorization document or a work permit 150 days after the filing date of the asylum application, assuming that there's been no delay caused by the applicant in the adjudication of the asylum application. The work permit can be issued at the 180-day mark, so 30 days after the 150-day mark is when the employment authorization document can be issued. The initial employment authorization document is now issued for 2 years, but that initial application for an employment authorization document does not have a filing fee. President Trump is asking for regulations that will allow a filing fee for that initial employment authorization document or work permit. However, and this applies only to people who entered the U.S. illegally, meaning without authorization, persons who apply for work permits before their asylum applications are adjudicated will be denied if the proposed regulation goes into effect if they cannot prove that they entered the U.S. with authorization. They can only get a work permit if their asylum application is favorably adjudicated. That applies also to withholding of removal applications, which is one step down from asylum. So those are primarily the three changes that apply to USCIS regarding application fee for the asylum application fee for the initial employment authorization document, and eligibility for an employment authorization document, specifically that one cannot receive an employment authorization document until approval if that person has not entered the U.S. with authorization. There is another change that any asylum application in removal proceedings, meaning before the immigration court, must be adjudicated within 180 days. That would impose a tremendous strain on the immigration court system, which is already heavily backlogged, but that is what the president is asking for. That, of course, would help some and also would hurt others. Depends on what type of claim you have and where you're located in the country. Anyway, so those are the proposed changes that have not gone into effect, that even 90 days from April 29th will not go into effect, but will potentially have proposed changes that are announced 90 days from last week. So just know that that hasn't gone into effect now. There's no filing fee for an asylum application right now as of May 6, 2019, and there's no filing fee for the initial employment authorization document for a pending asylum application. Also, even if you enter the U.S. without authorization, you can still get an employment authorization document per the normal rules while you're waiting for adjudication of your asylum application. And there's no rule that your asylum application in immigration court has to be adjudicated within 180 days of the case initiation. So those are some things to take into account. But generally, when it comes to asylum, not much has changed. The rules are essentially the same. One has to prove that he or she fears that he or she would be harmed if returned to their home country or whichever country they were residing in permanently, and that harm would be caused by the government or by people the government is unable or unwilling to protect you from. So that means that the harm, which can be either physical or psychological, that you fear you will suffer if you return to that country, is going to be directly done by the government of that country or by others, whether individuals, a group, whomever, that the government, in most cases the police, cannot, meaning they don't have the capability of protecting you, they cannot protect you, or will not, meaning they have the capability but they choose not to protect you. So those are some important factors to understand when it comes to asylum. It can't just simply be that I fear there's poverty, I fear there's crime. These type of generalized fears are not good enough unless we can say that that fear is actually going to be because of is of some actual harm that's going to be done by the government or by others that the government can't or won't protect you from. And this is very important. The fear of harm has to be based on one of the 5 protected grounds. Now, this is asylum specifically. It also applies to withholding of removal that is not based on the Convention Against Torture. And I want to limit this discussion only to asylum and for withholding of removal that is not related to the Convention Against Torture. The Convention Against Torture has a different standard where one fears that they will be tortured by the government or with government acquiescence. I want to focus solely on asylum and the related part of withholding of removal that is not pertaining to the Convention Against Torture. So the 5 protected grounds that one has to claim the harm they fear is based on are race, religion, national origin, social group, political opinion. I'll kind of go through them briefly and just give some examples. Race, the typical example of race would be that I'm a racial minority in my home country, and as a result, I will be harmed by the government or by people the government is unable or unwilling to protect me from because of my race. Religion, similarly, I am a religious minority or I have different religious beliefs than most of the country, and I will be harmed because of that. National origin, although I'm a citizen of my home country, my family historically came from another part of the world, and because of that ancestry or that national origin, I will be harmed. Social group, that is the big one that's been in the news. I'll kind of skip over that for now and talk about political opinion. Political opinion is that I have political beliefs and or I've espoused political ideas that are against the political party in power in my home country, and as a result, I will be harmed. And then we come back to social group, which is has to be particularized. It cannot simply be that I'm an Americanized individual, or that I'm a person who is afraid of crime, or I'm afraid of poverty. It has to be a particular social group. Examples of particular social group have historically been found to be family, homosexuals, and of course, what's been in the news, women who have suffered domestic violence, and people who have been harmed by gang violence. Now, these types of particular social groups of domestic violence and gang violence have been in the news because of the claims that have been made by people in Honduras, Guatemala, El Salvador, because of the conditions in those countries. And there's been an effort by the current administration to reduce what are perceived as frivolous claims from people in those countries. There was a recent case case decision issued by the former Attorney General Jefferson B. Sessions III, called Matter of AB, that many people have heard about, and was overturned by the U.S. Circuit Court of Appeal the U.S. District Court for the District of Columbia. That's very important to know the difference, because while that decision is limited only to USCIS, it is not binding on the immigration judges or the Board of Immigration Appeals. However, it does provide some level of instruction and persuasion as to the effect of Matter of AB. Matter of AB, of course, said that these domestic violence and gang violence claims are not the types of claims that asylum are supposed to be based on. But in the decision Grace v. Whitaker by the D.C. District Court, that was overturned. So there are a couple things to take into account regarding those recent developments. One is, one shouldn't just assume that a domestic violence or gang violence claim can now be approved the same way that it used to be before Matter of AB was issued, even though Grace v. Whitaker appears to overturn that decision. Instead, one should take into account the reading of that case and should work with an immigration lawyer who understands that case to try to develop a particularized social group that does not fall into the categories that Matter of AB says are not recognizable. So, for example, rather than simply saying, and this is just an example, I'm not saying that this should apply to anyone's particular case, rather than simply saying that I am a woman who cannot leave my relationship or marriage as a particularized social group, rather than saying that, maybe one would want to say I'm a woman who's viewed as property in my home country. And that way you kind of get around or get over the obstacles formed by Matter of AB. I'm not discussing the legitimacy of the obstacles formed by Matter of AB, but I'm providing some examples of legal strategies that have worked previously in regards to what Matter of AB imposed. So the particularized social group category, which many people like to use because it seems to be what's most applicable to them, is not the only one. And so race, religion, national origin, political opinion, those are still good categories to use if they are applicable to your particular case. And if they are, then Matter of AB does not appear to be completely applicable to your claim at all. However, I would not give up particularized social group simply because of Matter of AB, but I would try to form some solutions to get around it. Now, the other changes that have happened that's largely, what asylum law, that in the same asylum law that's been around for years. What the news has largely been about, such as the proposed regulatory changes in Matter of AB, are how that law can be put into effect, how it can be enforced, and another recent change that happened at the beginning of 2018 was how those applications are going to be adjudicated by USCIS. It used to be before January 31st, 2018, that it was a first in, first out system, which is the person who filed their asylum application the soonest or the earliest would get the earliest interview. However, what happened was because of the tremendous backlog, and I'll briefly talk about the reason for this backlog with USCIS. Basically, there were a number of claims at the border, and so asylum officers at the asylum offices, there are 8 asylum offices in the U.S., had to be reallocated to the U.S. border to accommodate credible fear interviews at the border for people who were trying to enter the United States. And that left a lot of applications languishing at the asylum offices because there weren't enough officers to adjudicate those. That created a huge backlog, and that created what the government viewed as an incentive for people who did not have good claims to file asylum applications, knowing that it would take years before the interview would happen, and therefore they'd be able to get a work permit during those several years waiting for an adjudication. And so the backlog kind of became even larger because of what the government perceived as many frivolous claims now being filed with the asylum offices simply for people to get employment authorization, knowing that they would never have to actually deal with the merits of their asylum claim until much later. So the solution that was proposed and that went into effect at the beginning of last year was for it to be a last in, first out basis. Basically, any new applications after January 31st, 2018 will be prioritized for an interview with the intention that application or that new policy would disincentivize or deter people from filing their applications if they were not or if they were frivolous, knowing that their interview would happen very quickly and they would wind up in immigration court very quickly in removal proceedings because their asylum application was not being approved by the USCIS asylum office. In practice, what we've seen is that some asylum offices are scheduling interviews much sooner than others, which is the way it used to be. But asylum applications that were filed before January 2018, particularly ones filed in 2015 and 2016, are still being unadjudicated. There are ways to get expedited treatment, including if you have dependents such as a spouse or children in your home country who cannot come to the U.S. until your asylum application is approved, and therefore you need to have your interview scheduled sooner. That's an example. There is a wait list that one can put himself or herself on, so that if there's an opening, then that day or the next day they can be called and come do their interview very quickly. But that's only if there's an opening because of maybe a cancellation. So these are some possible solutions to get a quicker decision on an asylum application if that's what you want. But otherwise, if those don't apply, then even if you file now, it depends on the geographical location in which you file. That will determine how quickly the interview will be, but it will be prioritized because it's a new filing. And those who have filed before January 2018 would still have to wait a long time, because the second priority are for people who are not, I shouldn't say second priority, but a secondary priority, or maybe even a tertiary priority, are the ones that were filed before January 31st, 2018, but moving backward from January 31st, 2018 toward older cases. So you have two different interview lines, so to speak. One that moves forward from January 31st, 2018, where the newest filings get prioritized, and the one moving backward from January 31st, 2018, so that the older cases are not as prioritized as they used to be, but only the newer older cases are being put on that secondary or tertiary prioritization level. And the even older cases, such as those filed in 2015 or 2016, will continue to have to wait a long, long time. Now, one might say, well, let me withdraw and refile. Well, that creates a different set of issues. A withdrawal probably would trigger being placed in removal proceedings. A refiling would suffer from a 1-year deadline issue, which of course pertains to the 1-year deadline. One is required to file an asylum application within 1 year of his or her last entry to the United States, or otherwise prove an exception. The exceptions are the extraordinary circumstances exceptions and the changed circumstances exceptions. Extraordinary circumstances exceptions relate to maintaining status or non-immigrant status or permanent resident status or temporary protected status up until a reasonable time before filing the asylum application, or having some kind of legal disability that prevented one from filing sooner within the 1 year. Changed circumstances relate to changes in the applicant's home country or in the applicant's own political or religious beliefs or mindset that now make them afraid of makes the applicant afraid of returning to his or her home country, whereas before, during the 1 year deadline period, the applicant was not afraid, or maybe the fear didn't rise to the level of a reasonable fear of persecution. So these are just some ideas to take into account. They're not particularized legal advice, but I want mostly for people not to be afraid of the asylum process, but to understand what obstacles are being imposed, what the law is and really has been for quite some time, and what needs to be done to be successful. When it comes to asylum, I always recommend people to get a lawyer. in some immigration cases, particularly simple marriage-based cases or simple naturalizations, I tell people honestly, you don't necessarily need a lawyer. But when it comes to asylum, I think you always need to have a lawyer. Anyway, this is Attorney Anish, and please tune in for our next discussion when it comes out. Thank you.